So the head of the National Prosecuting Authority, Shaun Abrahams, announcing today that the former president will stand trial for corruption and fraud. It brings to a head a prosecutions debacle that has dragged on for years in the court. Of the 18 original charges relating to 783 transactions, 16 charges now stand. They include one of racketeering, one count of money laundering, 2 charges of corruption, 12 charges of fraud. And let's just look back a little and see what we can in terms of history. Now, and remember in 2007, 28th December, Jacob Zuma, who was then the country's deputy president, was charged with corruption, money laundering and fraud, initially in relation to the 30 billion rands arms deal. This after his former financial advisor, Shabir Sheikh, was jailed for bribing Zuma. The court found that Sheikh conspired with Zuma and Thomson CSF, the French arms group, since renamed Thales. Now, that was a company that had sold corvettes to the government. It found that Thomson CSF had agreed to pay Zuma about R500,000 a year in exchange for his protection when the group was being investigated and for future support. Of those 18 charges, 16 now stand as we looked at them. One count of racketeering and others of money laundering, corruption, and 12 counts of fraud. Let's move forward now to 2009. Then the bombshell came. The prosecution's boss, Mokitedi Mshe, then withdrew charges against Zuma. The National Prosecuting Authority said that the charges were based on recordings of intercepted telephone calls among crime bosses known as the spy tapes, and Mshe said the tape showed that the prosecution was being manipulated for political ends. Let's move forward because, of course, that was taken on review. Then on the 13th of October last year, the Supreme Court of Appeal ruled that the withdrawal of those charges was irrational. The matter had been taken to the courts and they took the view that Mshe was not being rational. He's been criticized for not including top-notch prosecutors in the decision and not questioning the admissibility of the spy tapes, which seem to have been given to the prosecuting authority by Zuma's legal team. In October, the Supreme Court upheld the finding of a High Court that set aside the decision to drop the charges. Then the country waited to see what Shaun Abrahams would do, while at the same time he, of course, was accused of being pro-Zuma and not fit for office, also fighting for his job on another technicality. That brings us to today, the National Prosecuting Authority reinstating corruption charges against Zuma. Abrahams went further, saying that he was convinced that there was a reasonable prospect of success in prosecuting Zuma. Of course, remember, in a last-ditch bid to avoid prosecution, Zuma made representations to Abrahams in January this year. Abrahams gave us some insight into what those said. He said they paint a picture of impropriety on behalf of prosecutors, irrational decision-making, deliberately leaking information to the press, inexplicable delays in bringing the matter to trial. But he says he's decided that in the interests of the NPA and the interests of justice, the matter should be aired in an open court. A pending court judgment, of course, means that Abrahams' continued tenure is still unclear.
Good morning, good morning, good morning. Good morning, ladies.
Against Mr. Tana, described as the information leaking incident of 2021. C, the nature of the charges pertaining to the 2008 information leaking incident. And D, further and additional considerations which also have the effect of disqualifying Mr. Downer. Most importantly, in paragraph 101 of his founding affidavit, Mr. Zuma stated that any single one of the above mentioned grounds will be enough to justify the granting of the relief sought. He proceeded to state that cumulatively, all these grounds provide an insurmountable hurdle for Mr. Downer's intended continuation in the role of the lead prosecutor and/or prosecutor in the public prosecution. I begin with Pillar 1, the private prosecution of Mr. Downer. Mr. Zuma's request for the removal of Mr. Downer as public prosecutor is anchored on the private prosecution of Mr. Downer. It was argued that if Mr. Downer were to prosecute Mr. Zuma today and then be prosecuted by Mr. Zuma the next day, the society will make a mockery of our justice system. If that were the position, then I would not have hesitated to grant an order removing Mr. Downer as the public prosecutor. But that is not the position. As things stand, there is no private prosecution. All attempts by Mr. Zuma to prosecute Mr. Downer have been unsuccessful. I might just add that as at the date of the hearing of argument in the present application, the Supreme Court of Appeal had already made a factual finding that the attempt by Mr. Zuma to prosecute Mr. Downer amounted to an abuse of process. The Supreme Court of Appeal held as follows, quote, "The facts demonstrate that the private prosecution of Mr. Downer is an abuse of the process of the court for multiple reasons. First, as the High Court found, it was instituted as a further step in a sustained attempt by Mr. Zuma to obstruct, delay, and prevent his criminal trial. This is an ulterior purpose, and the institution of the private prosecution was accordingly unlawful. Second, it was instituted in order to have Mr. Downer removed as the prosecutor in Mr. Zuma's trial. This too is an ulterior purpose, which renders the private prosecution unlawful. And third, the contemplated private prosecution is patently and a hopeless case. It is obviously unsustainable. Mr. Zuma has not made out a possible basis on which Mr. Downer might be convicted, even on Mr. Zuma's own version of the facts. This, too, renders the private prosecution an abuse of process." Close quotations. C. Zuma versus Downer and another, square brackets 2023, ZASCA 132, square brackets 2023, all SA 644 SCA paragraph 11, hereinafter referred to as the SCA judgment. Pillar 2 relates to the alleged leaking of Mr. Zuma's private and confidential information to Ms. Moore. It was argued on behalf of Mr. Zuma that the fact that Mr. Downer is facing a serious charge of disclosing the confidential and private medical information of Mr. Zuma to Ms. Moore in breach of Section 41(6) of the National Prosecuting Authority Act 32 of 1998 disqualifies him as a prosecutor in the present matter. Firstly, Mr. Downer denied having disclosed Mr. Zuma's medical information to Ms. Moore. And secondly, the issue pertaining to the release of Mr. Zuma's medical information to Ms. Moore was thoroughly canvassed by Kun J in a removal application brought by Mr. Zuma in terms of Section 106(1)H of the Criminal Procedure Act 51 of 1977. In his judgment, Kun J found, as an undisputed fact, that Mr. Downer made no such disclosure to Ms. Moore. CS versus Zuma and another, square brackets 2021, ZAKZPHC 8 and 9, square brackets 2022, 1 all SA 533 KZP, hereinafter referred to as removal judgment. A similar finding was arrived at by the full court. Of this division. This finding was again confirmed by the Supreme Court of Appeal. It is important to note that every attempt to overturn Kun J's judgment has been unsuccessful. Findings made in the removal and private prosecution judgments are binding on this court. I now turn to deal with Pillar 3, the alleged leaking of information to Mr. Sam Soul. Again, this issue pertaining to the conversation between Mr. Downer and Mr. Soul has been dealt with several times at various litigation stages. Firstly, it formed a part of the spy tapes which were utilized by Mr. Zuma with the view of persuading the then acting National Director of Public Prosecutions, Mr. Mshe, to withdraw the charges against Mr. Zuma during April 2009. It again surfaced before Kun J. It was again dealt with by the full bench of this division and ultimately the Supreme Court of Appeal. In his judgment, Kun J made a finding that Mr. Zuma's accusations were, quote, based on speculation, unsupported by admissible evidence, close quotations. It is important to note that Mr. Downer, in his answering affidavit, disputed having disclosed any information to Mr. Soul relating to Mr. Zuma's case. In paragraph 118.5 of his answering affidavit, he pointedly stated, and I quote, I merely described in the abstract the mechanisms by which the MPA obtain mutual legal assistance, close quotations. It is worthy to be noted that in response to the above, Mr. Zuma merely stated in paragraph 97 of his replying affidavit, and I quote, here it was Mr. Breitenbach who initiated the conversation to achieve his own ends or those of the prosecution team. Mr. Downer joined into the enterprise and willfully associated himself with its criminal objective. In any event, the remarks of Kun J relied upon were not directed at the matter involving Mr. Soul. My emphasis added, close quotations. Pillar 4 related inter alia to Mr. Downer's indispensability. In argument, Mr. Mpofu submitted that Mr. Downer is not indispensable and added that if he were to be removed as a prosecutor, the defense will be ready to instantly proceed with the trial. This argument is not supported by the evidence. In paragraph 159 of his founding affidavit, Mr. Zuma stated, and I quote, it is, in my opinion, also very doubtful whether the current members of the prosecution team who have been inextricably involved in the current legal prosecution will qualify, but that is not an issue which requires the adjudication of this court at this present moment, close quotations. In response, Mr. Bartlander argued that the question for determination is whether our system allows an accused person to abuse the process by electing the prosecutor of his or her choice. He proceeded to say that if such a process were to be allowed, that will become a standard tool in the toolbox for well-resourced accused persons to abuse the process. He further expressed the view that our law does not tolerate such process. There is merit in that argument. Mr. Downer advanced numerous practical reasons why he should be retained as a public prosecutor, including the complexity of the matter, preparation for trial, availability of suitably qualified prosecutors, and the financial prejudice to the state. See Mr. Downer's answering affidavit, paragraphs 82 through to 93. It is worth mentioning that except for reiterating that Mr. Downer is not indispensable, Mr. Zuma did not deal with any of the above reasons in his replying affidavit. See Mr. Zuma's replying affidavit, paragraphs 75 through to 79. To conclude, I am satisfied that there is merit in the submission that the grounds advanced by Mr. Zuma were sufficiently dealt with in previous litigation. In his own words, Mr. Zuma stated in paragraph 160 of his founding affidavit that he is aware that some of his atmospheric issues had already been dealt with in previous litigation, albeit in pursuit of different causes of action. He concluded by stating, and I quote, "Whichever way they may have been construed in such previous litigation, they are now invoked merely to demonstrate that the overall atmosphere is sufficiently poisoned and too toxic to permit for any fair trial if Mr. Downer is or remains a prosecutor in the public prosecution brought against me." Having considered all the grounds relied upon by Mr. Zuma, both individually and cumulatively, I was unable to conclude that Mr. Zuma's right to a fair trial would be violated if Mr. Downer remained the prosecutor in the matter. Those are the reasons for the order I granted on 20 March 2024.
In anticipation of what happens now, my learned friends and I for the state have been in discussion as to a timetable, because we're now proceeding for the actual application for leave to appeal against the second removal application, against the dismissal of that application. So, my Lord, for your Lordship's convenience, I have typed up a timetable which we could hand up. Sorry, could you? And this takes into account the availability of counsel for all the parties. My Lord, if we could start off with the dates for the hearing, given the availability of counsel for Mr. Zuma and counsel for the state, we propose that...
Is this the date for the hearing of the application for leave to appeal?
The actual hearing, yeah, the last paragraph there. It's 25, 26 or 27 November and 4, 5 or 6 December.
I won't be available.
My Lord?
I won't be available then.
Or the 4th, 5th and 6th of December.
I'm not going to be available during the course of this year for the remainder of the...
You're not available?
I'm not going to be available in January next year.
In January of next year?
Yes.
My Lord, I'm sure that we haven't discussed that amongst council, but if your Lordship could give us a date, then we would, I'm sure, make a plan. But prior to that, my Lord, we also did discuss a timetable for the exchange of papers, and I think we could stick to that anyway.
Yes.
So that we could get that behind us and get ready for the actual application. And that is Mr. Zuma's supplementary application for leave to appeal based on your Lordship's further reasons, right. The 4th of October 2024. The date for our supplementary answer, that is the 11th of October 2024. Right. Mr. Zuma's heads of argument, the 25th of October 2024, and the state's heads of argument, the 1st of November 2024. I've indicated that that date might be movable depending on which counsel is available. My learned friends for Mr. Zuma have agreed that that might be moved on a week, so it might be the 8th of November depending on counsel. It's not going to make any difference given the date that your Lordship proposes to give in January. Okay. My Lord, we could then discuss the date for the hearing once we hear from the court. My Lord, there is just the further issue that this court has reserved the dates next year of the second and third terms, starting in April and running on then until basically the end of the trial and the availability of the court.
Yes, those dates remain reserved.
Remain reserved, yes. That is, so, my Lord, we will certainly argue that whatever the outcome of any application in January, the state will argue, and if necessary, we'll argue it formally and properly before your Lordship, that those dates in April must remain and the trial must start on those dates, whatever the status of any appeal processes might be going forward. Right. Because no matter what your Lordship decides in January, on the date which the court will then set, obviously, if it goes against my learned friends, then for number one, accused number one, they will take further up the line, in accordance with what we say is Stalingrad, and that this cannot be allowed to continue. And so we will argue that the trial we must all be prepared, our diaries must be open, briefs must be properly issued, preparations must be so that on the date in October, I think it's in April, I think it's the 15th of April, it's in the draft order we previously gave to your Lordship. It's the 14th of April, and the following terms. We will all be ready for trial. The state witnesses will be briefed, the police will be available, the court will be available, and my learned friends, certainly for accused number two, have indicated they're available. Mr. Mpofu, who's not here today, but he has indicated he is available on those dates. And we must make it now clear that we cannot simply carry on moving the trial on to accommodate a long series of appeals, which take sometimes years, up to the SC and the Constitutional Court. So we will argue. And we're happy with that the Lordship keeps those dates reserved under those conditions. May it please the Court, my Lord.
Okay. Can you prepare a draft order accommodating dates mentioned in paragraphs 1.1, 1.2, 1.3, and 1.5, and then leave a date open for paragraph 1.5? That is the date of the hearing. Also, I'm going to adjourn for a moment and discuss a date with the Judge President, because I don't even have a roster for next year.
As it pleases the Court.
Right. Mr. Buthelezi?
The Court pleases. Thank you, Madam. With the exception of the submissions on the dates, we obviously now have to take exception to the proposal that the dates for next year, April, remain reserved, simply because of the absurdity of the proposal. If already we can anticipate that we will argue the application for leave to appeal, not the leave to appeal, application for leave to appeal, in the first quarter of next year. What purpose is served if we can then enroll a matter that is, for all intents and purposes, from what we can anticipate, will still be the subject of an appeal come April next year? And for them to say, I mean, so casually, glibly, starting crowd, well, no, but we take exception to that because we are exercising our rights. So it's no creation of ours that this application is now going to be heard at this time of the year. Judgment was granted in March. Okay, so we'd never created that circumstance that causes the reasons to be given in September. So I think it would be prejudicial to the court to keep blocking those dates when we know now, as a matter of fact, we may have those holding dates, but to block out 2 terms is prejudicial to counsel, because Mr. Dana can't explain how it could happen that while the matter is being appealed, whether that leave to appeal is granted or denied, the appeal avenues that exist in as far as petitioning the SCA and petitioning further make it unfeasible that we would sit here with good mind and good conscience and assert that we're going to start the trial at the start of April next year. That's not pragmatic and that's not possible. So I'm not too sure whether the court can be cornered into putting that in an order. As we previously did it with your brother, Justice Kulu, we would have some dates, because we could not postpone the matter sine die, to come back and postpone the matter or update the courts. And then only once that certainty is ascertained can we then go back and say, because there's counsel for the second accused and ourselves as well, involved in other matters, to now have in September this year a commitment that says we're not available from the second time, when we already know that yourself, my lord, is not going to be available at the end of this year to hear this appeal. So we're already in Q1 of next year. So that's the only point, my lord. Other than that, we're okay. We just, in as far as the date of next year is concerned, our proposal is the second week of February for the hearing of the application for leave to appeal. Because
January, Mr. January, Mr. On the first
my leaders,
on the first
I have
available
to-
date, Mr. Buthelezi.
Well, end of January.
Right.
We were Lordship's hands. We were Lordship's hands. We were just putting the proposal on the table. Other than that, everything else was by mutual agreement, madam.
All right.
Thank you.
That's fine. Right. We'll stand adjourned, and I just want to consult the Judge President with regards to the dates that are available, because we don't even have a roster for next year. Cora James.
Good morning, good morning. Good morning, royals. Good morning, everybody. Good morning, kings and queens of the land. Today, judge giving reasons why he refused to remove Downer as the prosecutor. His reasoning unreasonable. I understand why in the first place he did not give the reasons. My name is Mngoni Mkhonto. This is the Royal Opinion. Click the like button and subscribe. I understand why he did not give reasons in the first place, because his reasons are totally unreasonable. It's basically out. The reasoning that he is giving. Let's remember President Zuma was not involved in the first place in the arms deal procurement. He was not involved in the arms deal procurement. He was not a senior. At that moment, he was in KwaZulu-Natal working for the Department of Economic Development in KZN. President Zuma was not involved. So secondly, on the issue involving Downer is already, it's a requirement. It's actually a law requirement that when a prosecutor has to stand in a trial, when somebody has to stand in a trial being prosecuted, the prosecutor himself should not have preconceived ideas, should not have already seen the person guilty, should be rational. So with Downer, it's not possible for him to be rational, because he's already proclaimed that President Zuma is guilty in different media platforms. He's already discussed the case in different media platforms. And here he says they are in a hurry. They want to, even when President Zuma appeal this ruling, they want to argue that the case should go on hearing, irrespective of the fact that the appeal is about removing Down. So as a prosecutor. So if the case continue in court, if the trial will continue while you've got an appeal on the other side to remove the same person, Downer suggests that this should work. The case should continue with him as a prosecutor, while President Zuma is appealing against that judgment that the judge had made, that Downer should not be removed as a prosecutor. So the trial should continue irrespective of the appeal. So what if at the end of the day it's found that Downer was supposed to be removed? What would happen then? What if already at the end of the day President Zuma was found guilty already before Downer is removed? What if President Zuma is taken to jail before the case of his case with Downer is concluded? So it's totally irrational the way this judge or this prosecution is working. It's totally irrational. The main issue that they need to achieve is to remove President Zuma and prosecute him, not because of any corruption that he did, but because of his politics, the politics of standing for black people. That is the reason why President Zuma has been prosecuted for so many years, for more than 25 years now. The case are not ending. It has been case after case. Some of the case, like this one, has been reinstated 3 times. Initially, it was found that this was a politically motivated case, and the NPA dropped the charges against President Zuma. But the white people brought it back because they don't have any other thing to remove, to fight President Zuma with. They have to use this case. They don't have any other case that they can use against President Zuma. The main aim is to get President Zuma to go to prison, lynch him, discipline him, show anybody else who stands to liberate black people that whatever they are going to try, they are going to face maximum force from the colonial masters, from the white people. That is the whole issue about the trial. The issue is not that President Zuma, obviously, justice delayed is justice denied. Already, the justice has been denied for President Zuma. This case alone has been going on for more than 20 years. So that is justice which is denied. It's justice that has been denied already. So I think so the whole issue about prosecuting President Zuma is just about that. It's about stopping the MK party, stopping him from leading the MK party to liberate black people from colonialism, from racism, from slavery, to liberate black people from the slave traders like Ramaphosa and Julius Malema. Those are slave traders. President Zuma is prevented basically to help black people to liberate themselves from the shackles of colonialism and slavery. President Zuma has been pursued for more than 25 years in court. Different cases have been reported. I think if we can compile a report and to find how many times how many times was President Zuma taken to court, I'm sure everybody would be shocked. I'm sure President Zuma is the only person in South Africa to have been taken in and out of court so many times, to have been wanted by the white system, because President Zuma has been fighting the white system for about 68 years now. He's been fighting the white system for about 68 years. So he's been on the wrong side of the law, of the apartheid law, and he's on the wrong side of the neo-colonial laws which are governing South Africa at the moment. South Africa is not free. There's no freedom in South Africa. There's never been any freedom in South Africa. Black people are still slaves. Whatever was a lie. It never happened in South Africa. There was never a time where black people were free to vote for what they want, because the rigging of the votes have been happening since. White people have made this system is their own system. The courts have been rigged. We know that the courts judges have been paid. We don't know these judges when they are talking, whether they are talking from the fact that some of them were bribed, or whether they are talking the truth. So we can't trust the judges as well. They are part of the system. President Zuma, being the only politician who has been prosecuted, but for the sake of his politics. President Zuma has never sold out. We don't know. I don't know about Thabo Mbeki. Maybe some other people can judge. Nelson Mandela, we can say somehow we know that he's been representing the white people. Nelson Mandela, everybody is afraid to talk about him selling out. There's nobody who is talking about Nelson Mandela clearly that he's a sellout. But I think he's a sellout. He's been a sellout, Mandela. Mbeki is a sellout. I think he was supposed to just keep quiet at the moment. He must never say anything, because we black people, we don't know where he stands. We don't know whether he's for white or for black. He's just a confused politician without understanding of, I would say, misunderstanding the local politics. If he's not a sellout, if he's not a sellout, he does not understand the politics that is involved in. But I think he's a sellout as well. Ramaphosa, it's a given, he's a sellout. So President Zuma, Kgalema Motlanthe is a sellout. President Zuma being the only person who did not sell out to the white system. President Zuma being the one who is being pursued for not selling out. President Zuma is just being pursued for not selling out. Click the like button and subscribe. My name is Mgodum Konto, and you are on the Royal Opinion. We're talking about the case which involves President Zuma. Where it comes from is President Zuma has applied to the court for the court to remove his prosecutor. President Zuma applied to the court you can comment on the video. You can give us your opinion as we're talking. You can as well click the like button. You can subscribe. You can give us a super thanks if you have something to give. You can give us a super thanks to support the Royal Opinion. At the moment, we're talking about the case of President Zuma. President Zuma having been prosecuted by the system. But what I wanted to explain is President Zuma has applied to the court to remove Billy Downer as a prosecutor in his case. He gave several reasons. One of those reasons, which is critical and important, is that he must be partial. So he's not a partial prosecutor. He's somebody who passionately wants President Zuma to be prosecuted. He has said this clearly on news platforms. He has spoken about the case outside the court, which is not allowed. But because the white system does not have anybody else to prosecute um, uh, President Zuma except for this Downer guy, it will be tough for them to get somebody who will start the case afresh, familiarize themselves with the case, and also be able to find facts about the case, because there are no facts about the case. It's only fabricated stories. So when President Zuma used the law to ask the court to remove Downer, they say it's delaying tactics, while it is actually provided in the constitution. It is provided for everybody to be able to protect themselves when people are abusing them. So this is a case of abuse of the law by the system, the prosecution of black people who are not selling out, the prosecution of black people who really stands for liberation and freedom of the black man. These people are ruthless in their prosecution against those such people. This thing has been happening like that. People have been lynched. Previously, people were killed publicly. Robert Sobukwe was killed. Steve Biko was killed. Just to prove that anybody who stands against the system, it shows us that people like Nelson Mandela, the reason they kept them is because they were cooperative to the system. So people who really stands against the system are pursued by all means possible, sometimes poisoned, sometimes killed on cold blood, on guns. They were, or sometimes taken to jail with lies. They normally do that. President Zuma, they have already taken him to jail on nonsensical case where they said he was taken to jail for 15 months, where they said he was actually abducted. He was kidnapped by the state. It's just that when you are kidnapped by the state, nobody is there to rescue you. So he was kidnapped by the big mafias of the land, the state or the white people, taken to prison without trial and without him doing anything wrong. Without trial and without him doing anything wrong. They said it was contempt of court. Contempt of court, which he was never invited to attend. Contempt of court, which he has never been invited to attend. Contempt of court, which he was not part of the trial. So basically, President Zuma was just kidnapped and taken to jail by the mafia state in order to silence him, to stop him from talking and from fighting for the rights of black people. Click the like button and subscribe. If what I'm saying you can hear, if it makes sense for you, just click the like button and subscribe if you haven't. My name is Mngoni Mkhonto and this is the Royal Opinion. We give news and opinions, discussions about serious issues that affects black people in South Africa and also in the world. Serious issues that affects any serious issue that affects black people we discuss here. So today we're talking about President Zuma and his bid to remove down as the prosecutor of the state. I would like to appreciate your attendance of this live session. Click the like button and subscribe, everybody who is available. I would like to thank everybody who attended the session and everybody who somehow participated wherever they are. I would like to end the session here. Thank you very much.